It reads that James Eric Davis Jr. did on or about March 2, 2018 in the city of Mount Pleasant, county of Isabella, and state of Michigan. Count 1, did murder Diva Davis contrary to MCL 750.316. That is a felony in the state of Michigan, carrying a maximum penalty of life, and DNA is to be taken upon arrest. Count 2, open murder, did murder James E. Davis Sr. contrary to MCL 750.316. That is a felony in the state of Michigan, punishable by life, DNA to be taken upon arrest. Count 3, felony firearm, did carry or have in his possession a firearm, to wit, a pistol at the time he committed or attempted to commit a felony, to wit, open murder, contrary to MCL 750.227B. That is a felony in the state of Michigan, punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory. Can you afford to hire your own counsel, attorney? Pardon me?
No.
Okay. The response I heard on this end was no, Mr. Blanchard, is that correct?
That's what he said. I think it's just our audio equipment. I'm trying to get the microphone closer.
Okay. But that was his response. No, he cannot.
That is correct.
All right. And you want court-appointed counsel, Mr. Blanchard, to continue representing you, sir?
No.
You want to proceed without counsel?
No. I mean, yes.
All right, I think what I would like to do in light of the mixed responses there, Mr. Blanchard, is continue your representation for the time being, and we'll give you an opportunity to withdraw after you've had some time to privately consult with the defendant.
Yes. Your Honor, I don't mean to interrupt, but on this point, I've discussed it with my client. He's directed me to try and, I suppose, extend the time for the probable cause conference. I've also discussed it with Mr. Kowalczyk. I think it appropriate, given his situation in the hospital, that we waive the 14-day requirement and set the probable cause conference outside of that.
All right, Mr. Davis, do you agree with what Mr. Blanchard just said?
No, can you re-explain that, please?
All right, you have the right to a probable cause conference between the next 7 and 14 days. You have the right to a preliminary examination to be held not less than 5 days or more than 7 days after the probable cause conference. Basically, those hearings are to determine whether there's probable cause to believe a crime was committed, one or more crimes committed, and probable cause to believe that you committed those. That would be in front of a judge. You understand that?
Yes.
Did that help clarify it for you?
Yes.
Okay.
And the court should set it as such. Mr. Davis Jr. is not from Michigan. He's from Plainfield, Illinois, and that's his primary residence, is my understanding. In addition to that, he did attend Central Michigan University, but again, his primary residence is in the state of Illinois. So he does have family that we understand reside out of state, and his contacts in Michigan are as attending college as a college student. And therefore, and because of the nature of counts 1 and 2 being punishable by life, obviously it's the highest graded criminal offense in the state of Michigan, so it goes without saying how serious it is, and as a result, the defendant would be a flight risk. So as a result, we believe that bond should be set at $3 million cash. Thank you.
It's not a permissible bond condition to set cash only. MCR 6.106E1 A and B provide that the defendant's option whether it goes cash or surety. It's not at the court's option to set a cash only bond. So I don't think the court can set a cash only bond. I think when the court's considering what kind of bond to set, setting $3 million is the equivalent of denying bond. Particularly for a 19-year-old college student. If the court were to deny bond under Subrule B, we get a contested evidentiary hearing on it. And so backdooring it by setting it at $3 million cash really denies Mr. Davis the right to have a meaningful consideration and a reasonable bail that he's entitled to under the United States Constitution, the Michigan Constitution, and the court rules. So I think the bond is excessive. I think it's worth noting he has no criminal history. There's no record evidence of non-appearance or failure to appear. There's no record evidence, frankly, on any of the factors in subpart F of the court rule, except that it's a serious crime. And we recognize it's a serious crime, but that can be dealt with through conditional release orders. For example, a GPS tether could mitigate a lot of the concerns.
All right, on count 1, the court's going to set bond at $500,000. Count 2, $500,000. Count 3, $125,000 for a total of $1.25 million cash or surety.